So my paper is based on the fact that, I've thought about consent a lot. Actually, I wrote this paper after thinking about consent for decades. And so this is kind of the best I could come up with. I'll just say this before I get to the next slide. And so I hope you like my thinking on it, because it's like, more than 20 years in the making. I've been thinking about, well, how can we deal with consent? Because I struggled with this issue year in, year out. I just couldn't figure it out until finally I had this idea. And that's what prompted this paper. But it's been a dilemma that I just couldn't quite figure out for a while. So I want to bring to start, uh, professor and philosopher Heidi Herd once said that consent is a form of moral magic. And I really like this term, because what she means is that consent can transform something that would otherwise be illegal or immoral into something that's okay. And so she writes that consent turns a trespass into a dinner party, a battery into a handshake, a theft into a gift, an invasion of privacy into an intimate moment, a commercial appropriation of name or likeness into a biography. And so what consent does it's so transformative, and it's really key to privacy, because in privacy, we're often asked to consent to gathering and use of our data. And if you don't have consent, uh, then those uses are often illegal. But if someone gives their consent, privacy law generally says, not always, but generally says, that with consent, you can do almost anything. And so, consent is it's in the GDPR. It's one of the lawful bases. So if you get someone's consent, you can process data in the way that you got their consent for. And in US law, there's a very robust consent. So if you get people's consent, you can do what you want with the data. Now, I contend that privacy consent is a series of fictions. It's it's basically, to use a technical legal term, consent is bullshit. I don't think people can really consent to privacy. I think that consent under all the approaches to consent are so flawed that I think it's fictional. I think it's just, not, and there's a lot of debate, and I'll talk about that, between different methods of consent, and I think all of them don't work. Now, why is this a problem? Because I think consent works like dark magic when it's fictitious, and it provides legitimacy and power. So when someone gets consent to use your data, when they think they've got your consent, now they have this power to use the data the way they want, and it confers legitimacy on that, right? Hey, we're not using it, in a dicey way. We got your consent. You agreed to let us do it. So it's a blessing. And I think this is dark magic because it's an undeserved blessing. It's undeserved legitimacy. Now, this is the dilemma. Uh, well, if consent's fictitious and it's a farce, should we just get rid of it? And the problem is, we really can't. We really can't get rid of it. And that is a real problem. If we got rid of consent, what about people who want the use of their data? What about people who I want to use my cell phone, my iPhone. I want my smart doorbell. I might want to get, I might want, free Facebook with the ads. I might want, free internet if it comes at a cost of ads. I might be okay with that. I might want the use of my data in a lot of different things. And should this government tell me, no, you can't have it, even if I really want it? That's a problem. We generally think that people should have autonomy and should be able to make choices in their life. So this is a tricky thing. This gives rise to the consent dilemma. as I've called it. You can't live with it, you can't live without it. And so what do we do? How do we work consent into privacy law if it's always fictitious, but at the same time it's always uh, fraught because it's fictitious? So I propose murky consent, a new way of thinking about consent, and I'm going to propose 4 different duties, which I'll talk about later. So you're going to see this slide again. This is just a quick little preview of where I'm going with all this. So take a quick look, but this is a preview to keep you excited as I go through first a little bit about the law. So here's the law. And now I'm going to talk less about my kind of normative views and more about, okay, what does the law say? And this is important because this is about the different approaches to consent and privacy law. And if you take them all, they're basically boiled down to two methods, which is nice. There's really 2. And if you look at most privacy laws, it's going to be one of these 2. The notice and choice approach and the express consent approach. And both are bad. Both don't work, in my view. But let's look at notice and choice. So notice and choice, this is an approach very common in the United States. We've talked about this a lot. This is where the idea is you put what you want to do with the data in the privacy notice. You make a statement, and it's a little thing, and like you go down a website, you'll see a little thing saying like privacy or privacy notice or privacy policy. It's usually next to the terms of service. Sometimes it's incorporated into the terms of service, but there's a little privacy notice, and you click that little thing. I don't know if you've ever done it. And then you get to a page, and it says all this stuff about what they're going to do with privacy. And then the idea is that, basically, if you don't do anything, if you continue to use the website, and you don't opt out or you don't stop doing business, you are deemed to have consented to what they've said in that notice. That's how this approach works. And the problem with it is, basically, we know no one reads this stuff and no one does this stuff. And so a lot of this is a joke, with opt-out. And that's the view of the EU and the GDPR and a lot of countries that say we reject the notice and choice approach. They require express consent. Express consent is affirmative consent. Opt-in. So the idea opt-out is basically, you're consented unless you say no. But express consent means that in order for you to consent, you have to affirmatively say yes. You have to affirmatively click the box. So opt-out would be you're signing up for an account, and you see this box, and it says, sign me up to your newsletter, send me ads, etc. Text me, and there'll be the box, and it'll be checked. That's an opt-out because they pre-checked it for you. You have to take an action to undo it. Opt-in means that the box is not checked, and you have to affirmatively check it. And so this is the idea. And generally, countries that use the express consent approach in the EU, when they look at notice and choice, they hold their nose. They're like, oh my gosh, how stupid and smelly the US is. This reeks. It's such a stupid approach. How can you possibly assume consent from someone doing nothing? That's not consent. That's just a complete and utter joke. I think they're right. I mean, I think, it's ridiculous to think that someone who doesn't opt out or, doesn't read the privacy notice is consenting to anything. It doesn't mean that. So they think, oh, we're superior, we're better because we have this express consent. And I think express consent is a lot better, but it still fails. And it fails for a lot of the same reasons that the other approach fails. So in a way, like one approach is they're both fictional. Express consent maybe is a little more true to life, but so notice and choice is like the movie Airplane, And, express consent is like a movie that's a little bit more realistic, but still, still somewhat fictional. It's like Star Wars. So anyway, here we go. Why is this the case? Well, consent is a fiction, and there are many different aspects of this that make it fictional. So let's look at some of these problems here. One is that there's a lack of indications of consent. So with notice and choice, it's pretty clear why there's a lack of indication, because we have no idea. Did people even read the notice? Do they even know what they're getting into? Do they even know what they're consenting to? And the answer is no. There's no indication. How do we know? Because we have no idea, right? They didn't do anything. But the problem with express consent is we have the same problem. Express consent means you throw up a button, accept, or you have to check a box. But just because someone clicks an accept button does not really mean, are they really consenting here? Because what we have happen a lot of times is that most people who click accept don't read the thing. So I don't know if you have an iPhone, or this happens in other sites where suddenly, like some days they'll say, here we have new terms of service, right? And I look at that and it's something like 60 screens. And then, but luck, oh, thank goodness, the accept button's on the first screen. So I click accept. So, did I read it? No, I just clicked accept. I didn't read it. And oftentimes, do you accept our cookies? Here's the cookie banner, and you can read more about the cookies. Do I understand the cookies or what they do or the risks? No, I just click accept, go the heck away. So clicking accept, is it really indication of consent or not? I don't think it is. There's a lack of understanding and reading. I mean, we know statistically there's been a lot of studies to show that hardly anyone reads privacy notices. I think it's less than 1% or around 1%, very, very low. So that's a problem, right? We have no one reading these things. So, and then if they read them, do they actually understand what they mean, what privacy is all about? I'm not sure. I mean, they're confusing. They're often unclear. They're vague. Why are they done? Because that's a feature, right? They're made to be vague because lawyers write them and they don't want to tie a company's hands. So there's they're not written to be wonderful prose. They're written in a way that is it's like dense and confusing for a purpose. And that's the other problem, is that merely making information about one's privacy policies available doesn't really mean that people have seen or read it. So we really don't know, are people actually reading this stuff? And a lot of times what we see is that they're in fact not. And then the problem is, even if they read the notice, there's no effort to make sure they understand it. So if we really wanted to make sure that people understood a privacy notice, they should basically force you to read it, and then you should be given a quiz. Let's give a test on the privacy notice. Do people actually understand what they've read? You know why they don't give a test on a privacy notice? Because everyone would flunk. Everyone would fail it. And that's the thing, is that why are there no good indications of whether or not people understand it? The reason is because if we actually tried to find out how much people are understanding, we don't want to know. Companies don't want to know. You want to bury their heads in the sand and pretend that people are understanding when they know they're probably not. That's the problem. Okay. Another problem is the dilemma of complexity and simplicity. And this is this dilemma because, do you write a privacy notice that's really complex, that accurately describes what's going on, or do you make it simple? Well, a lengthy notice is more meaningful, right? You're going to actually explain what you're doing with the data, and that's complicated, right? Privacy is not easy. How data is used and combined and shared is complicated. The problem is that the longer and more complex you make it, the harder it is for a person to understand it. And don't forget, most people reading it are not lawyers. They're not privacy experts. They're just ordinary people, and they're busy. So if you make it really long and complex, you're going to lose them. So then other companies say, let's make it really simple. And they'll make these really simple policies like, we love your privacy, we care about your privacy. And they're so simple, like, we, do, whatever, we share it with people we trust, we give it reasonable security. What do these things mean? They're vapid statements that tell me nothing of meaning. So if you make it really simple, the problem is that you're now losing the substance of what is being said, and you're not really telling people what they need to know, which is, well, what do I really need to know about my privacy, right? Essentially, I think what most people want to know is, will it, what's the risk, right? What are the benefits? What's the cost? Okay, what am I going to get if I share the data? And that's easy, right? People say, oh my gosh, I'm going to get cool stuff, cool technology. What am I going to risk when I give up this data? What's the harm to me? Is the risk worth the reward, right? That's what I want to know. But I don't think people are being understanding that in the privacy policy. Another is the lack of expertise. Most people don't have expertise to really understand what the risks are. And that's a problem. There are just too many unknowns. Really, if I want to understand what is the risk of sharing my data with a company? What's the risk if I share my data with, various companies? Well, it's hard to say, right? To really understand the risk, I need to have a lengthy conversation with the chief privacy officer. I need to review the data transfer agreements, review privacy impact assessments, right? I want to see, well, what are the risks? Well, you have these assessments. I should see that, right? I want to talk to the engineers, like, how are you engineering the site? What are you doing? What are you going to do in the future? I want your future plans. I want to see the data map. What data are you gathering, and how are you storing it? I want to see your algorithms. Are your algorithms any good? But hey, I need to know the data they're trained on to really understand the algorithms. You need to know what data they're being fed. So I need all that data too. And I want to talk about your security. Just saying reasonable security is not good enough. I want to talk to your CISO and see, are you doing pen testing? Are you teaching employees about phishing? How good are your vendors? Because a lot of times the breaches are because they have some third-party vendors. Are you vetting them? Are they good? Are they not good? The bottom line is, like, to really do the kind of analysis that I need to do, it's going to take me months to do that kind of fulsome analysis to make that judgment. And it's just too many unknowns for me to actually figure this out. There's a problem of scale. If I have to do this for one company, but wait a second, there's a lot of companies out there gathering data, like practically every company. That means hundreds, if not thousands of companies that are gathering and using your data. So now I'm going to do this for all of them. And that becomes really hard. Then we have consent fatigue, which is that if I'm constantly going to be asked for consent, I'm going to get a little bit annoyed by it. I don't know how many of you have traveled to Europe in the last 5 years. How many have gone to EU, especially EU, I should say. Do you ever go, when you step there, do you notice that, like, every website has that stupid cookie notice, that banner? Every time you go to a site, you get the stupid, like, do you want cookies? Accept, or, check, see more information about cookies. And after, like, the umpteenth one, I'm about to scream, like, damn, this GDPR, I can't stand it. If this is what privacy is just a stupid annoyance, and I can't take it. People get fatigued. And GDPR says, by the way, that anytime you want to have a new use of the data that wasn't specified in the original privacy policy, you have to get people's consent again. So companies could be not just asking me for consent once, but like all the time as they come up with new uses. So not only am I going to get like 1,000 consent requests from 1,000 different companies, but now each one might have 1,000 different uses. that they want to get my consent for. So, oh my gosh, like this just doesn't scale, and I get sick of it. And that we're back to the consent dilemma. What do we do? Can't live with it, can't live without it. But I have an answer. This is my answer. So I think a lot of folks have tried to make consent work. And so what they recommend is, well, if we just improve notice, if we improve things, it'll be better, right? Just make like instead of like the privacy notice being little, like California's answer, like let's make a button that everyone has to put on their site and it has to be conspicuous that says, do not sell my data. Let's put warnings more prominent. Let's all go with the GDPR, make it all opt-in consent. That'll fix it. Let's make consent be like anytime they want to get your consent, there should be a pop-up box, like pops up on your screen, right? Interrupts you and asks you for consent because then you can't ignore it, right? All these things are basically trying to take privacy consent and make it less fictional. And I think the bottom line is privacy consent is fictional and can't be made less fictional. And we should, in fact, go the other way. We should lean into the fictions instead of trying to try to sort of clean this up and it's still going to be a farce. What if we said that, in fact, privacy's fiction should stay fictions, that the consent is just always going to be fictional. Stop trying to fix it this way. You're not going to make it truthful. You're just going to try to pretend like it's not a fiction, but you're not going to really turn it into fact. So what does leaning into the fictions mean? Means what I call murky consent, which is that consent is should be understood to be murkier. That and murky consent is my term for consent that is dubious. That consent is fictional, it's dubious, it's messy, it's ugly, it's murky. And the idea of murky consent is to recognize that consent should lack some of the magic. The way consent works now is that once you get consent, it does this moral magic. But what if we said that consent, what if we take the magic away? And that's the move I want to make. I want to take consent and weaken it. I don't want to get rid of it, but I want to weaken its power. And I think if we deflate its power, we, in fact, will do better. That consent still plays a role, but what if it lacks the power it has? Right now, consent's like this magic that does all this stuff and gives all this power and legitimacy. But what if we took that away? What if we have consent without the magic? And I think that if we think this way, consent should be less legitimate. Consent also isn't binary. Right now, it's very binary, right? You either get consent and you have everything's legitimate and it's okay, you can use it, or you don't have consent and then you can't. So it's either or. What I propose is something kind of in the middle. Like a lot of situations, well, it's not kind of either or. It's kind of, sort of. And that's what I want to do. I want to weaken consent's power. And if the law can do this, I think we'll be in a much better shape. So how does the law do this? Well, I think by leaning into the fiction. The way it does is this. We can't escape the fact that privacy consent is a fictional story, but we can demand that the story end happily ever after. So we can force the ending of a consent story. So instead of just saying, okay, you have consent and now that's the end, whatever you do is okay, I say the law should now impose, if we're going to assume, we're going to allow fictional consent. We're going to say, yeah, consent's a farce, it's a fiction. Okay, we'll let it go. Well, let's make sure the story ends happily ever after for people. We're going to imagine that people consent. Well, then we should imagine that that it works out for them. And right now, the law doesn't do it, right? We imagine that people consent. We fictionalize people's consent, and then it could work out really badly for them, and we're like, tough luck. I think no. I think we should say, no, we imagine your consent. Now we're going to make sure it ends happily for you. So this is where the duties come in. I think there are 4 duties, and if we impose these duties, we can go a long way to protecting against the problems that fictional consent can do. So first duty is the duty to obtain consent appropriately. Now, I've just said, okay, what about all this problems? If consent's a fiction, should we care about how it's obtained? And I think yes, because just because it's a fiction doesn't mean that there's a different, that means everything's fair game. There's plausible fiction and like terrible fiction, right? And when there's a plausible fiction, you watch a show and it's a good, right? They like think about a show like Breaking Bad, which I really like. And one reason I like Breaking Bad is they don't have like ridiculous, stupid plot holes. Like in some other shows where the plot holes are so big that you can drive a Mack truck through them. And it drives me crazy. It's like, come on, really? You mean to tell me with like, $100 million budget and like all these writers and everyone on the set, like really, how could you possibly make a movie like that? I'm thinking of like remember the Indiana Jones and the Crystal Skull, right? The one that's like so absurd that made me want to shout when like, a nuclear explosion blows, up and he jumps in a refrigerator and it flies like and lands and he's fine. And at that point, I just said, that's just, it's dumb. I can accept a lot of fiction. I can accept a lot, but there's a point when it gets stupid. And I think this is the line, that we should make sure that people don't just cheat and lie and use fraud and deception to obtain consent. It should be appropriate. And we should get the appropriate consent for the situation. Even though we know it's fictional, it doesn't mean there aren't good and bad fictions. So that's one part. We're gonna write a story and we're gonna write a fiction. At least let's write one that's good. Then I think the next duty is to avoid thwarting reasonable expectations. So the idea is that we will say that consent's not valid if it thwarts people's expectations. We'll say, what's a reasonable expectation? And if the data is kind of used in ways that are inconsistent with that, let's invalidate the consent. Even though people consented, if it's not consistent with their expectations, then we should just invalidate it. Now, I'd say reasonable expectations, which means that, it's not just some individual has, their own weird expectation. No, we should look at what's reasonable for society based on the situation, what they should generally expect. And if something's an outlier, sorry, you can't use it that way. Then I think a duty of loyalty. If you're getting murky consent, you should put the interests of individuals before its own. So they should really look out for, if I'm consenting to, if you're going to make a fiction that I consented to something, well, we should also make the fiction that I'm consenting to something that I'm going to benefit from. Why would I consent to something that gives me nothing, but that sort of benefits you and could harm me? So we have to make sure that, hey, if I'm consenting, I'm going to come out ahead. You should, my interest should win out. If we're going to make that fiction, then let's make the fiction that I consent wisely. And finally, a duty to avoid unreasonable risk. That, if we're going to say consent's fictional, well, then we shouldn't, put the risk on people. We should say, look, if I'm consenting, I think that the risk should be a reasonable risk that I undertake, not something that is unreasonable. And that protects me against the bad consequences that might happen for this fictional consent. So then I'm not being like fictionally consenting to something and then bad things happen to me when I didn't really meaningfully consent. So organizations are going to say, when you go to these duties and you start talking about this, it's going to create some uncertainty. And I get this a lot when you hear businesses talk about privacy law. They get furious when the law is uncertain. They hate standards like unfairness because that is, they don't know what is going to happen and what that means. Or if they say, oh, okay, it's unreasonably risky or harmful. They don't like these standards. And you hear all this moaning and groaning of companies saying, oh my gosh, we don't know what to do and we're at risk. And my answer to them is, well, your data puts us at risk, right? It puts people at risk. So why shouldn't you be at risk too? You don't like being at risk. You don't like uncertainty. Well, welcome to what you're doing to everybody else. if I have to give my data, I don't know what you're going to do with it. And there's all sorts of uncertain things that could happen to me from the data. Well, maybe, if I have to live like that, why shouldn't you live like that? So I kind of think, it's good for what they do to people. It's good for the company. So I don't shed tears for their dealing with some uncertainty. They'll deal with it. They're big, they're grown-ups. They can, so they might whine, but I think they can ingest and deal with uncertainty. Um, they're better at it than they're actually designed to deal with this stuff pretty well. So I don't shed tears for that. They'll manage. Um, Beyond consent. Uh, this is one point about this is that maybe there are situations where maybe we don't want consent. Maybe there are instances where we say people shouldn't consent to certain things. Should I be able to consent to buying a dangerous product? Should I be able to consent to engage in a gladiator fight to the death? And I think we say no, right? There are certain instances where we say people can't consent to certain things. Could someone consent to driving like a really dangerous, badly designed car that has no seatbelt? So we say no. In fact, there are cars that are safer and cars that are less safe, but you still have minimum safety requirements. And I think the same thing goes with privacy. We need some minimum requirements.